Next, we talk to attorney Aaron Maduff, who is representing the State Universities Annuitants Association in their lawsuit against the state over pension reform. Mr. Maduff gives us the most recent developments of the lawsuit against the state over the contentious issue. This runs about 15 minutes.
Aaron Maduff, thanks for joining us again on the Illinois Channel. As we have discussed with you before, we're focusing on the ongoing legislation as it moves its way through the court system relative to the state having passed a bill that would have reduced the pensions. The governor signed it into law, but its enactment has been held up for judicial review. You are working with the State University Annuitants Association and are the lawyer in that case as it is moving through the courts. You're one of the lawyers working on that. And so, as those who have been following our interviews know, we have talked about where we stood. Now, as we tape this on August 28th, there's been another hearing. And
in a different case,
and I was going to say, and part of this had to do a little bit different than what we've talked about before, having to do with the implications of the health care benefits to retirees. So with that kind of a general overview, let me throw it to you, and you can give us an update on what specific were the issues and how is this going to be impacting those who are retirees with the state?
Well, let's be clear to begin with. We have two separate laws that SUAA is challenging. The one that we've been talking about primarily, although we have spoken in terms of Kanerva, has been what we call the in-re pension litigation. That is the challenge to the General Pension Reform Act, which was changing the way that pensions were being computed to the detriment of the pensioners. That case is still ongoing. The next court date in that case is September 4th, and we currently have a motion in that case pending to ask the court to stop discovery in light of the Supreme Court's decision in Kanerva and rule on that case based on the pension clause challenge. The reason for that is that there are similarities between the two cases. The case in re-pension litigation is challenging Public Act 98599, which I've called the Pension Reform Law. But the Kanerva case challenged Public Act 97695. This is an act that came earlier that required the state to make deductions from pension checks from pensioners for 2% of their pension to cover health insurance premiums. In July of this year, that was doubled to 4%, and it was 2%, but only 1% for those people who are on Medicare. So those people were doubled to 2%. There are several steps. SUAA has been fighting this on a number of fronts, and I found myself in different courtrooms and in different places to try and fight all of these issues. The first thing that happened is that when the Kanerva decision came down July the 3rd, SUAA contacted the governor and said, look, the emergency rule that the Department of Central Management Services has put in place to double the amount being taken out is wrong.
The deduction taken out of retirees' pension checks to pay for their health care.
To pay for the state health insurance premiums.
That was wrong. Okay, so I just wanted to remind people. So
sure. And that's the other case, that's 97695. Now, normally the way the system works is that 120 days after the rule is put together, a Joint Committee on Administrative Rules called JCAR, which is a committee of both senators and representatives, review the rules and they approve or disapprove of them. Because of the letter that SUAA sent, the JCAR committee put it on their agenda for August the 12th. They put it on in 60 days rather than waiting the full 120. We immediately wrote a very detailed analysis of the Kanerva decision, setting forth for the governor, for JCAR, and for the Department of Central Management Services why the deduction was unconstitutional and why we felt that the Supreme Court had now spoken on the issue. In response, the Department of Central Management Services withdrew that doubling rule. The practical effect of that is that in July and August, people probably saw that 2% or 1% double to 4% or 2% of their pension checks. And the result of that is going to be now that the pension checks coming out in September should go back down to 2% being taken out and 1% being taken out. In other words, it stopped the doubling, but that was just one step. We still had the problem that 2% is being taken out.
Or that any is being taken out. Right?
Exactly. Exactly. So the Supreme Court's opinion in Kanerva was returned to the Sangamon County Circuit Court on, I want to say, August 12th or 13th, somewhere in that area. We immediately, on behalf of the State University Annuitants Association, filed 3 items with the Sangamon County Circuit Court in the Kanerva case, the 97-695 case. The first was a petition to intervene on behalf of 24 State University Retirement System employees, as well as the State University Annuitants Association, so that we can be plaintiffs in that case. The second thing that we filed was a motion for immediate judgment based on the Supreme Court's opinion and a permanent injunction barring the state from taking any money out at all. Or in the alternative, a preliminary injunction so that it would stop immediately and we can still sort through the issues. Now, what happened is that that first court hearing was up today. The court granted our petition to intervene. SUAA is now officially a plaintiff in the Kanerva case, the 97-695 litigation. Our motion was up along with 2 other motions for injunctive relief, asking for something similar, and a motion from a third party that said you can keep taking the money out, but segregate the funds. The court granted our motion for preliminary injunction. The result is that as soon as the state can stop deducting that 2%, they will. As a practical matter, it's a little bit like a 10-ton truck going 90 miles an hour. It can't stop in 5 feet. The state has already sent out pension checks for September and has already started working on them for October. And as a result, the 2% deduction may still be coming out, certainly in September and May and October, but SERS members who are seeing those deductions for state health insurance premiums can be pretty confident that they're not going to see it out for November. They might not see it out for October. At some point, once we complete what has to be done in this case, we hope that the court will enter a judgment finding the statute unconstitutional and prohibiting the state permanently from taking those monies out. However, during the court call today, the court said that it is going to permit the state to file its responsive motions. The state's responses are due October the 13th. We have 21 days, which I think is November the 3rd, to file our replies. The court has set a November 21st date in this case, and so we will be coming back in this case to address those motions on November the 21st, at which time we hope that we'll have a judgment entered and the preliminary injunction barring the 2% being taken out will become permanent.
So just to summarize briefly here, if you're a pensioner and you're listening to this and you've had these deductions taken from your check to pay for health insurance, come October, but surely by November, when you get your pension check, the deductions that the state had been making will no longer be there because of the injunction that you got from the court today.
Exactly.
On the other hand, the court has yet to rule that those deductions should be permanently banned. They still have to make that ruling, but at least now, while we're waiting the final decision, the money will quit being taken out of their check. Now, one question I have, what about the monies that have already been deducted? Will those then be returned to the pensioners?
That's the next step. We have also filed a motion for class certification for SERS members who are suffering it. SUAA represents SERS members. SUAA has the expertise with regard to the State University Retirement System. The object of that motion is to enable us to collect money that was taken from these pensioners over the last year, put it together and redistribute it back to the people whose pockets it came out of. That may take a little bit more effort because it means we have to unwind it. It's going to be some litigation. I asked the judge today I told the judge today that I wanted to reserve the right to do some discovery if necessary. He certainly asked the state already, how are you going to do it? But some of that money may have gone back to the general revenue fund. Some of it may still be within the CSRS system. We have to sort that out. So there is some litigation that's going to continue because we want to recover that money. And of course, it's also going to sort of shape the pension challenges to come, both the 98-599 case that we're already involved in, and further legislation that is coming down the pike. I mean, the reality is still there that the state owes something like $100 billion in pensions, and it is attacking that problem by trying to lower the amount that it owes in pensions. So there's going to be more legislation. This is going to be an ongoing fight. But right now, it seems like everything is going in the pensioners' favor.
Isn't there also a motion or an effort being made get the court to issue a decision on the constitutionality of the pension bill in light of the Kanerva decision, where they came out and said pension or health care benefits are pension benefits? And anyone who's kind of followed this, when they heard the Kanerva decision on July the 3rd, said, well, that more or less, they've shown their cards. The Supreme Court have shown their cards. And if they're going to rule that way on Kanerva, then surely they're going to say it was unconstitutional to be diminishing the benefits, the pension benefits. Where does that effort stand, or where are we on that effort to get a fast track for a decision?
That case is still pending. We will be back on September 4th it's a different judge on that case. What we accomplished today is huge because the fact that the judge in this case has issued the preliminary injunction is an indication that he feels that he's very likely to enter the permanent injunction, finding the healthcare issue, the law on the healthcare pensions deductions, unconstitutional. That's going to be something we're going to use. We filed a motion a couple of weeks ago, maybe it was last week, in the other case, in 98-599, saying, look, read Kanerva. Based on that, we should bring the 98-599 case in repension litigation to a close. The problem you've got is we've made that request several times because our reading of the law has been that the pension clause is not subject to any defense. Now, to refresh your recollection.
Is that the same as saying it's indefensible?
It's not subject to an affirmative defense by the state to attack, to violate it.
Okay.
This is what we were talking about last time, that the pension clause is there, it clearly protects these pension benefits, and the state has come back and said, well, but pursuant to the police powers, we can abridge the Constitution. That is to say that the pension clause is subject to that defense by the state that they can abridge it anyway. That's the state's view. We have believed all along that the pension clause is not subject to that. They can't simply violate it because they have an emergency police situation. And we've been arguing that. In order to prove that emergency situation, the state has selected 7 expert witnesses. It says that it has 7 categories of fact witnesses. There's a huge amount of discovery and litigation, and it's going to be very labor intensive for us to pursue.
To support the police powers argument?
For us to attack their police powers argument. Exactly. And so we have twice gone to the Sangamon County Circuit Court and said, look, since the pension clause is not subject to that defense, you should rule on the pension clause issue alone. And if you find in our favor, we don't have to go through that work. The Sangamon County Circuit Court has been very clear, at least the last 2, maybe 3 times we've asked for that relief, that it wants to put together a complete record. It's going to have us go through all of that discovery. However, in light of the Kanerva decision, we filed another motion saying, look, we've asked for this 3 or 4 times. We understand, Judge, where you're at on this, but we think that the Kanerva decision is a game changer. It tells you where the Supreme Court is at. And therefore, you should stop all of this discovery, rule on the question of whether or not Public Act 98-599 violates the pension clause, and if so, put an end to it. That's all she said. He hasn't ruled on that. That is up on September 4th. We don't know what the state's response to it is going to be. What we do know is that today's hearing, in which the judge in this case made it pretty clear that he thinks that this is now over and that the pension clause has been violated by the health insurance premiums. There's been no raising of the police powers. We admit that, but he spoke today that his reading of the Supreme Court's decision seemed to indicate that there is no police powers defense. So we're going to be raising that with the other judge in the other case next week. So this is a big boost for all SURS members, not just those who were facing the deductions for the health insurance premiums.
Okay. Unless there's something else, we appreciate you joining us again, and hopefully we can follow up again then as the issues become clearer.
Very good. Thank you very much, Terry.
You're watching the Illinois Channel.